Welcome back to another episode of Well Said, where I interview policy experts, commentators, academics, and students and activists on topics of higher education and free speech and other related topics in American culture and policy. You can share this episode on Facebook or YouTube, as well as any podcast platforms such as Apple, Spotify, Anchor. Download the episode and listen anytime. If you like what you heard today, give our podcast a 5-star rating and go to our website, speechfirst.org, and press donate. So I'm very excited to welcome back to the show Lathan Watts, the Vice President of Public Affairs at the Alliance for Defending Freedom, to discuss a huge win in the U.S. Supreme Court last week in the case 303 Creative versus Elenis. Many of you know that the last couple of weeks have been big in the Supreme Court for higher education and free speech, with Biden's unconstitutional tactic to buy votes by forgiving student loan debt without the approval of Congress, or when the court finally calling out affirmative action practices in the universities for being downright discriminatory. So there was another great ruling in favor of plaintiff Lori Smith, who is an artist who runs her own design studio called 303 Creative, specializing in graphic and website design. So this was a huge win, everyone, for free speech, and a big loss for government-compelled speech. Here in America, an individual's right to free speech is just as protected by the First Amendment as their right not to espouse ideas or be forced to speak things they do not believe in. So Lathan is going to walk us through this case, as well as dive a bit deeper with me in some of the bigger questions this lawsuit either answers or has brought to the forefront of policy discussions regarding protected speech. So thanks again, Lathan, for joining us. I will first start us off by having you just kind of give us some background on the 303 Creative versus Elenis lawsuit and kind of what brought it about, how it progressed through the courts, and then ultimately kind of just walk us through the decisions that came down.
Certainly. And thanks again, for having me back. Certainly, glad to be here celebrating a big win. Really, to get the real background of 303 Creative, you actually have to kind of go back to the Masterpiece Cake Shop case, also in Colorado, because Lori Smith is also in Colorado and saw what happened to Jack Phillips in his case. And starting her own studio, website and graphic design, and knowing that she would like to at some point offer her design services for custom websites for people's weddings that lots of people do these days. But having seen what happened to Jack Phillips, trying to run his business according to his beliefs on specifically on the issue of marriage, and having similar views on the issue of marriage, she understood that the Colorado Civil Rights Commission, that if she went into that, if she expanded her business into that she would likely be forced or attempted to be forced to create messages that she just could not in good conscience create. And so she filed what's known as a pre-enforcement challenge to this law and the Colorado Civil Rights Commission, the way it was being applied. And pre-enforcement challenges really go back many, many years, and they're sort of a hallmark of civil rights litigation. And it's kind of based on the idea that if there's an unjust law out there, you shouldn't have to violate it and suffer the penalties, civil or criminal, in order to get a case into court to challenge the validity of that law. So you should be able to say, look, this law is on the books. It would apply to me if I did this, and it's wrong, and I'm here to challenge this law. And that's what she did. At the federal district court level, the state of Colorado and their Civil Rights Commission, they agreed to the stipulated facts of the case, that Lori serves all types of customers, including LGBT clients, that she had received requests for wedding websites, both traditional marriage and same-sex marriages, and that she based her decision on the message that was being created, not who was requesting it. So those facts were agreed to at the federal district court, at the trial court level. They were not disputed when we appealed to the 10th Circuit, and they were not disputed when we appealed the 10th Circuit's decision to the United States Supreme Court. And even Justice Gorsuch, during oral argument, summarized it by saying, so, she makes her decision based on the what, not the who. And I was listening into oral argument and I heard that and I was like, please let Gorsuch write the majority opinion, which it turns out he did. Yeah.
Right.
So having seen what happened to Jack Phillips and not wanting, to be subject to the same sort of government coercion, she filed the pre-enforcement challenge. And thankfully, once it got all the way to the Supreme Court, it was, a very sort of, I wouldn't say simple, but a very straightforward free speech question. Can the government coerce anyone to speak a message with which that person vehemently disagrees? And thankfully, the Supreme Court in a 6-3 decision said, no, it cannot. This is basically the flip side of the coin of censorship. Government telling you can't say that. This is government telling you must say this.
Right.
And so it is a very, very big win for free speech. And it's a win for everyone, because Lori Smith, if she wins, then if you're a website, designer in Colorado, and you're a big proponent of same-sex marriage, and somebody comes into your shop and says, I want a custom designed website explaining why marriage is only between a man and a woman. Well, if Lori wins, then you win. You don't have to create that message. Right. Your decision to engage in speech based on what that speech is, not who's requesting it, regardless if they're a protected class in other contexts. Your decision on what speech you're going to create, what message you're going to put out there, is your decision. And the government cannot force you to speak a message that you disagree with. And so it's a huge win for everyone. Unfortunately, a lot of people are really kind of misconstruing the facts of the case and what the decision really means for everyone. But
we'll get into that too, because there are a lot of weird narratives floating around. How it's like, man, it makes me think too, with some of the stories that have come out. People really have no faith in the judicial system anymore. They genuinely believe that everyone's just lying to them all the time, which is a concern of its own.
Certainly, yeah. But it's a win for everyone. And we said this all along. If Lori wins, everyone wins. If Lori loses, then, the government in your area may get to decide to tell you what message you have to speak on an issue that's important to you.
Yeah. And okay, before we dive deeper into kind of some of the major consequences of the case for free speech and what would have happened if she had lost, let's dig a little bit into a couple things. You mentioned the pre-enforcement. She saw that there was this law. It was going to force her to espouse a certain message that she didn't believe in. I think the Colorado law, can you explain that a little bit? Because I'm pretty sure it basically she would have had to write verbatim almost of what they would have wanted, or they would have had to approve her messaging in a way or edit it, right?
It's basically a public accommodation law, which is intended to make sure that people don't deny services based on, like a protected class, like race, religion, sex. And the great thing about the 303 decision is that it shows that public accommodations laws and the First Amendment can and should coexist.
Right.
Because she's not basing any sort of decision based on who the person is. It's not based on their identity. It's based on the message they're asking her to create. Right. And so it in no way, enables any sort of discrimination that is already prohibited and that's protected by, accommodation laws. And so that's really, that and its sort of enforcement arm, the Colorado Civil Rights Commission, is what she was challenging by saying, this shouldn't apply to me because I do accommodate everyone. I just make my decision about what speech I'm going to create.
So what was unique about the Colorado law that basically made it any different than any other kind of federal anti-discrimination law?
I think it was in text. It's probably not that unique. It's how it was being applied.
I see.
It was stretching it to this degree that said, if you don't want to create this message, you are somehow discriminating against the person who requested it.
Right.
And that's just simply not true. As I said, they stipulated to the facts that she has LGBT clients, and she does work for them on other other causes, other issues. There's just certain messages that she's not comfortable creating.
Right. And the biggest difference here that was really teased out in the litigation process was the differences between actually discriminating via providing services versus discriminating on, like was basically saying, I'm not going to espouse an idea that I don't believe in just to make you happy or just to make you feel better about yourself. And that's what we see a lot of the times, especially on college campuses, where a lot of this tamping down on speech is to make everyone feel happy, or, a lot of universities try to create policies that enforce essentially censorship laws on campus in order to force students to be to avoid hurting each other's feelings. But what it really does ultimately is it just prevents people from speaking. So that's the big issue here. And in the United States, like we've mentioned before, this is something that we have very far-reaching and very liberal, small L liberal, free speech policies in this country, unlike many other countries around the world. So it is something that I think, especially if we're constantly comparing ourselves to other countries, the younger generations have a hard time grasping a lot of these concepts because they never really existed in a world where speech was very limited or where people were trying to come in and take away your rights. So because they never had to face that directly, to them, this seems like, oh, it opens us up to like hate speech and biased speech and things that we don't want, bullying. It's like, well, actually, like you said, this is a win for everyone, because let's talk about what would have happened if the court did not rule in Lori's favor on this case.
Yeah. So, the government in Colorado could then force her to create this message. So if you're say on the other side of an issue, like to put it in these terms, so let's say it's a very conservative government, a very conservative state, Texas or Arkansas, or one of those places, and you are a videographer, documentarian, who happens to be very pro-choice. And I walk into your shop and say, my pro-life group is going to participate in the March for Life for the first time this year. And I've seen your work. You do great work. And I would like to hire you to document and create, a short film about our experience at the March for Life. Well, if Lori lost, then, under maybe a more conservative government, could force you, that pro-choice videographer, to film my group's participation in the March for Life when it contradicts everything you believe on that issue. And so there's a quote, I was looking it up to make sure I didn't butcher it. Thomas Paine, he that would make his own liberty secure must guard even his enemy from oppression. For if he violates this duty, he establishes a precedent that will reach to himself. Right. And this seems to be the big point that everybody seems to be missing about this. They get so caught up in what Lori's beliefs on the issue of marriage are and their disagreement with them that they miss the big picture, that what she believes and what message she does or doesn't want to create is almost irrelevant to the law in the case. The point is, can government force you to do it? Right. If there's a winner and a loser here, the winner are everybody in America, free speech, and the loser is government, coercive government. So, I saw some of the immediate reaction, and there was a line from a Tarantino movie came to mind, which I'm not even sure I should admit that I've seen, but the main character turns to a guy next to him and says, "Are you such a loser that you don't know when you've won?" And
that's pretty good.
And so I bet you didn't expect Thomas Paine and Tarantino in the same interview. But that was like one of the first things that I thought of. I was like, you won. Everybody wins here. You're so myopically focused on what her beliefs are and how you don't like them that you're missing the big picture here.
Well, this is a lot of the times, again, like what we see on campuses, what we see with other forms of censorship. When you talk about oh, let's define what some of these terms are. What is hate? What is bias? What is a microaggression? These are all incredibly subjective terms.
Right.
And so we're losing sight of the objective reality, which is that, what is important to us ultimately is that we can express our ideas, whether or not you disagree with them. The whole reason the First Amendment exists ultimately at the end of the day, when we're talking about, sorry, not First Amendment, but like the free speech clause of the First Amendment exists ultimately, has more to do with the fact that we are protecting unlikable speech or speech that's going against the grain, speech that's going against the government. That's what it's really ultimately trying to protect, because the founders understood the dangers and perils of allowing a government to be able to censor and coerce its citizens. They'd seen it before, they'd experienced it.
Yeah, absolutely. I mean, they were keenly aware of the potential of the tyranny of the majority.
Right.
Which is why they wanted, all viewpoints to be able to be expressed. It's necessary if you're going to have a pluralistic society, and if you're going to have, a little r, a republic, a democracy, where free speech not only benefits the speaker, but it benefits the listener. Like if you're going to make an informed decision on an issue, you need to be able to hear from all sides of it. And some people express these things, inartfully, and less tactfully than others. And it might make you uncomfortable. It might even hurt your feelings. But there is no right to go through life without ever experiencing some sort of discomfort. There's no right to never have your feelings hurt. There is a right to speak your mind and for the listener to hear what's on your mind and make a decision for themselves. And so it's essential to our way of life and our form of government.
And so let's talk about the Masterpiece Cake Shop and the connections here, because we've talked about the law. Now, would the pre-enforcement, would Lori have been, how successful would this have been? What would the potential have been had the Masterpiece Cake Shop case not happened, had that not occurred, had the decision not come down from the Supreme Court? What would we have had to wait for the state to enforce this law against someone and to violate their rights in order for her to do?
Yeah, even without Masterpiece, I mean, pre-enforcement challenges are still very common in civil rights litigation. So even without Masterpiece, I think she still would have been able to file a pre-enforcement challenge. But I do think that the attention that the Masterpiece Cake Shop case brought to this issue, Justice Gorsuch brought up in oral argument to believe it was the Solicitor General from Colorado, that he brought up Jack Phillips and said, he's like, Jack Phillips, was basically vindicated by this court. And I'm paraphrasing here, but he said, didn't you guys basically put him through some sort of re-education camp? And that's so good. Yeah, you're having a tough day at the office when you get that question from Justice. And the attorney said, well, I wouldn't characterize it that way. He said, well, how would you characterize it? And well, he had to be sort of educated, trained on what his responsibilities were under, the Civil Rights Commission. And Gorsuch basically said, well, one could be forgiven for mistaking that for a re-education camp. And that was another one of those moments listening in. I was like, boy, I hope Gorsuch writes this opinion. And he did. So even without that case, I mean, she still could have brought a pre-enforcement challenge because the law was in place. But I do think that everybody, that case did bring such attention to this issue that it did sort of kind of lay the foundation for this case.
Right. And it gave her so much more to work with when it came to proving that she had standing, right? That she was able to, she saw what the repercussions were going to be if she had that law enforced against her and she had to fight it. Then, Jack, how much millions of dollars, how much money had been spent, how much money had he lost by having to close his business, by being boycotted, all of the things that followed. And he's still in litigation, right? He's still
going on 11 years now.
Wow. It turns your life upside down.
Yeah, absolutely. And the folks that are interested in coercing people into speaking this message, they understand that the process is the punishment.
Right.
It's a big part of the punishment. And the fact that when his case was decided, in our previous court, Justice Kennedy, it was a very sort of thread the needle kind of decision. And they really didn't get into that straight up free speech question. Can the government coerce him to speak this message? Right. Which is really why this case had to be brought forward.
Right.
because basically what Justice Kennedy said was that the Civil Rights Commission was clearly biased against his beliefs, and therefore, he didn't get a fair shake from the Civil Rights Commission, and Jack Phillips, Jack Phillips wins basically.
Right. And that turns it into more of a religious liberty case, right?
Right.
And so let's tease that out a little bit with Lori's case, because I think initially when the 303 creative case hit the news waves, it was very much characterized as a religious liberty case because of her beliefs, because she's Christian and she had certain beliefs about ways of life, that the government was essentially trying to coerce her to renege in order to satisfy their law. So a lot of people thought this is like a religious liberty case, but really what I think you guys did a great job with messaging and us, just trying to inform the public, this is a free speech case ultimately. And even though, regardless of her beliefs, this was primarily a free speech, was answering the free speech question that the Masterpiece Cake Shop lawsuit did not get to. And I think that, it's there, but this is why the public is a little confused by it. So it did one thing in that it added fuel to the fire, that is the far left trying to characterize this as an anti-LGBTQ kind of bigoted decision, which we can get into a little bit later. But what it also did was and I think this is partly because this is how the American public thinks of the First Amendment, it tied together these concepts of religious liberty and free speech in a way that a lot of people hadn't talked about before. So why don't we tease that out a little bit more, if you can kind of delve into it, and just talk about ultimately like what the purpose is of both of these clauses of the First Amendment.
Right. So Lori's case is a pure free speech case, because it is about government coercion of speech. Now, her reasons for not wanting to speak that message are rooted in her faith, but for the legal analysis, it is strictly on free speech grounds, and that's it's sort of it can get a little convoluted, but for legal nerds, it's like it's almost like two separate bodies of constitutional law. If you're talking about a religious liberty, there's a religious liberty analysis in this line of cases. If you're talking about a pure free speech claim, it's a free speech analysis. It's these line of cases, but the overlapping protection is right there in the First Amendment. The free exercise clause and then the free speech clause, because the founders were very, very keen to protect the proper role of religion in a free civil society, and the free exercise of religion, being able to live according to your faith in all aspects of your life, including talking about it, or including the decision not to say something that conflicts with those religious beliefs, because it's very hard to live according to your faith if you can never say anything about it.
Right.
And so that overlapping protection, if there is a case where the speech in and of itself is religious, then it has double protection. It's got free speech protection, it's got free exercise protection. This was what most constitutional scholars would say is a more pure speech analysis, even though her reasons personally for not wanting to speak that are rooted in faith. But they wanted that overlapping protection, like I said, because they wanted to preserve the proper role of religion in a free society. They did not want there to be an official state-sponsored church. That's the Establishment Clause. But they wanted religion to flourish, because they knew that for men to be free, they have to be good.
Right.
All of human history has shown, like our Constitution is founded on this idea of ordered liberty. If you just have order and no liberty, you have tyranny. If you only have liberty and there's no order to it, you have chaos, which kind of eventually leads back to tyranny. And the French Revolution sort of proved them right on that.
Yeah, it did. Yeah.
So that's the role they were trying to preserve for religion, not to coerce anybody, not to compel anyone to support a state church, or you don't have to be religious, you don't have to go to church, you don't have to do any of these things, but that for free men to live amongst other free men, they require a baseline of morality, not to use that freedom to abuse someone else or to infringe on someone else. And that sort of common baseline of morality is what they expected the role of religion to be, that this is where we learn how to treat other people, how to be good people, to be good enough to be trusted with freedom. Right. Because every time, throughout human history, if people are just free to do whatever they want, the strong will oppress the weak.
Yes.
Someone will take something from somebody else. Those who get into power will do terrible things to stay in power, and do terrible things with that power. That's
because power becomes the ultimate end in that point, in that
exactly.
Capacity. And what ends up happening is you use all means necessary and all means justify the ends in order to keep that
exactly
power, right.
They knew that is the fallen nature of man. Mm-hmm. Right. They were very, very aware of that. Adam said our Constitution is written for a moral, religious people, wholly inadequate to the government of any other.
Right.
So that's why there's that overlapping protection. And that's why, even though this case is a pure free speech case, people did probably initially kind of mistake it for a religious liberty case because her beliefs on marriage are rooted in her faith.
And you kind of wonder sometimes if it was an intentional mistake on the parts of those who are trying to create a different narrative around what this case represented, because they themselves are threatened by religious liberty in the United States. They're threatened by the more kind of moral concept of religion, in that it's important and valuable and absolutely necessary to society. There's many in this country now who are probably don't represent a majority, definitely don't represent a majority, but are a small minority that like to speak about religion as if it's detrimental to American society and culture, and then therefore would be totally okay jettisoning the religious liberty clause of the First Amendment, and in that case, all the other clauses of the First Amendment, because they are all connected to the concept of like freedom of conscience and being able to espouse your own beliefs. So before we go down that rabbit hole of like essentially like kind of what the reason and ultimate motives are to for the type of coercion that we're seeing these days, I do want to talk about these false narratives that we've touched on a couple times. There's false claims by the New Republic. Oh my gosh, so many articles. I didn't notice it until I had seen one. I didn't know how many they had actually written about this. They're very obsessed with this, like saying that this is a fake case, and this is all a setup. And and talking about how basically the Supreme Court heard a fake case and they made a decision based on it that was specifically designed to harm LGBTQ plus communities. And so I'm kind of curious, what's your whole take on this? How do we combat false narratives like this about respecting free speech, of course, right? Because this is completely a misunderstanding of the lawsuit.
Well, first of all, I find it hard to believe that anyone would think that the New Republic figured out something that the lawyers for the state of Colorado could not figure out.
A good point.
And honestly, whether or not one person that requested a website, a wedding website, was doing so under false pretenses is irrelevant to the law in the case. She has a right to file a pre-enforcement challenge against this law that would force her to create this website, whether or not the person who sent an email saying they wanted it was really this or really that. It's honestly, it's irrelevant to the law of the case. And as I said before, Colorado stipulated to the facts that she had received requests before and after filing the suit for these types of for wedding websites. So, and from kind of a personal or ADF perspective, we get anywhere between 2,000 and 4,000 requests for help every year.
Wow.
And we don't have to make up cases. We can't do all the cases that people want us to do because we don't have enough lawyers. We don't have enough money. We don't have enough time, resources, all of those things, which is why we're so careful about selecting the cases that we're going to do. Because, we're a C3. We don't charge the clients. We're supported by donors. So we're trying to get the most out of each case that we do to provide a good return on that investment our donors make. So that's why we are so intentional about what cases we're going to do and vetting, the facts and the clients and all of that. But to say that we somehow, would fake, again, we don't have to fake anything. We've got, I think, probably somewhere in that neighborhood of north of 200 cases in active litigation right now. But we get anywhere from 2,000 to 4,000 requests for help. So we're barely scratching the surface of these cases. We don't have to make anything up. Are you kidding me? And if this was even remotely true, you think Justice Sotomayor might have mentioned it in her dissent?
Right. It's very insulting to the intelligence of the Supreme Court justices that they actually would even hear a case, as if there's no research done in advance, that they would hear a case. They would be so fooled by something like this. But I think it speaks to a deeper issue, which is kind of what leads us into ultimately the type of coercion that we're seeing all over the country right now, not just on campuses, but also in cities. I think it was, I want to say Michigan state, they just recently passed a law through their Senate. I think the House still has to approve it, that essentially makes it a felony to not use someone's preferred pronouns. And I think that you have to pay a $10,000 fine. And that's about what we have been seeing in Canada, where people have actually been jailed for not using correct pronouns. So these types of forms of compelled speech and coercion to espouse ideas you don't believe in, forcing the public to take your side, there's a very totalitarian tactic. I mean, this is not new to society. These are totalitarian practices, things we've seen all throughout history. But I want to hear your thoughts on what the ultimate goal of some of these false narratives are, not just on the 303 creative case, but around just why, about free speech, calling it evil, saying that it opens doors up to hate speech, and that that's even worse than the free speech concept itself, and what the significance is of us losing that ultimate culture for free speech in this country because of these totalitarian tactics.
Yeah, I can't get inside the heads of folks that work for New Republic, nor would I want to, frankly. But so as to their motivation, but I think it's sort of almost, again, kind of our own fallen human nature when you think you've lost to try to explain it away or minimize its impact or come up with excuses or whatever. But again, they didn't lose. Coercive government lost.
Right.
No.
Well, they lost if they want a coercive government. If they want to be a governing party that is coercive, that's the only thing. That's the only conclusion I can come to, is that they do feel like they've lost.
Yeah, and maybe that's it. But it's a very sort of it's a very short-sighted view of liberty. Because you are basically operating on the assumption that everything you believe will always be the cultural orthodoxy. And if you look at, say, like Jack Phillips, in his original case, the Civil Rights Commission compared his views to those of like white supremacists and I think neo-Nazis and other things. And then go back, say, 50 years when the ACLU won the Skokie case. Defending the rights of neo-Nazis to hold a rally. It doesn't take long for something that was once maybe kind of culturally mainstream to now be really out of fashion culturally. And you never know what belief of yours or what some opinion of yours that's very, very important to you that may be just fine with everybody else right now that you're teaching your children that maybe 10, 15, 20 years from now, your children are going to have to deal with being the ones on the flip side of this.
Right.
And so, that's why, we just keep coming back to this. If you want to protect your own speech, you've got to protect it, even for the people that you disagree with. Whether or not you share the same beliefs as Lori Smith or you find them completely reprehensible, you should be glad that she won. And you should be hoping that ADF continues winning these cases so that in the future, some view of yours that, is non-controversial today, but a few years from now, may be the most controversial thing, your freedom to continue to speak it and live according to it is still protected.
Right. Absolutely. One thing, this is going to shift gears a little bit, but I am kind of curious to hear if you have any thoughts on it. So Lori's company, 303 Creative, is a digital It mostly operates in the digital world online. So she creates websites. That's part of one of the main things that she does. So is there any precedent in this case? And I know we're all kind of thinking it because it's like, oh, online communication, online speech. There's a lot of talk and there's very little precedent around online speech right now. So just like, you have companies who are trying to regulate it and censor it, being influenced by the government or being coerced by the government. We have yet to really tease that one out completely. But what is, does this set any kind of precedent for online speech, or is this just completely separate speech question? Or do you think this could be a decision that is recalled or like called back to in an opinion in a future online speech case?
Yeah, I could see it as it's sort of taking a step, another step forward in considering the whole concept of speech and speech online and what is speech, because that was, again, one of the facts that was stipulated to all the way back at the district court level, that her activity was pure speech. Right? Now, where it's different from, say, some of the other things that you've mentioned is she's creating it from scratch. It's completely custom. She's creating it and putting it on, which is different than using an online platform that already exists, like social media or other things, to express yourself there. And that brings in a whole, other bucket of issues. But I do think that the principle that the government cannot coerce you to speak a message or on the contrary, censor you from speaking a message, that principle is even more firmly established, may play into how some of these other cases play out when, as you mentioned, it's kind of come to light the government's role in some of these things with some of these platforms. Yeah. So I don't have a crystal ball, but I do think that this probably firmly establishing that principle and the fact that it was a website, but it was created from scratch and put out there, is maybe something that will be considered in the future on these other issues dealing with social media or other online platforms.
Yeah. No, that makes sense. I'm really curious to see how, Alan, if it does play a role at all in that decision. Okay, before we wrap up, I just want to get your thoughts on what are some of the challenges that you and ADF foresee kind of in the light of this recent win or other free speech cases or other areas kind of around the same issues regarding the First Amendment. What are some of the issues that you see kind of coming to the forefront of our conversations with all this?
Well, we're still very busy, on college campuses, just like you, protecting free speech on college campuses. But one area that people might not have heard much about is that we have a case in the state of Washington, a client named Brian Tingley, who's a therapist, a Christian counselor. So he provides counseling services from a religious perspective. So the people that come to him are likely looking for counseling from a faith perspective. The state of Washington passed a law that is basically a counseling censorship law that says if a person is dealing with gender dysphoria, the only permissible therapy response is to affirm their gender. So if it's a man who thinks he's a woman, you have to affirm that, yes, he is a woman, and help him become, more comfortable with his female identity. That is the only therapy, that is the only counseling that you can provide. So if a client comes to Brian Tingley and says, I'm struggling with this, and I want, from my faith perspective, help becoming comfortable with the biology that God gave me. If he gives that counseling that they're seeking, he is breaking this law and is subject to civil and criminal penalties.
And this is a clear violation of his rights. I mean, this is again, it's very similar. You have the state once again trying to dictate what someone is doing, not only in their
preferred message.
Right. Their preferred message. Exactly. And it's like actually speaking the words that the state is writing out for you and spelling out for you. That is the clearest cut version of compelled speech I've seen.
Yeah. And it's invading the most, private and sacred space you can imagine, a therapist and his client.
Right. Yeah, not to mention the client protections that exist around, therapists, psychiatric therapy, and all of these types of things, medical therapy.
Right.
Yeah. Oh my gosh. Yeah. Well, good luck in that one. That's a huge question. That's going to answer a lot of stuff. I'm looking forward to seeing that in the news. Yeah, and you saw also not too long ago, I think California is, I don't know if they passed or are attempting to pass a law that says if parents don't affirm their child's gender identity, then they will be subject to the state coming in and actually taking their children away from them, which is terrifying for all of us to think about. But again, another form of coercion from the state. Yeah, it's not letting up, and it's a matter of, again, this is why documents like the Constitution exist. They transcend time. They transcend popular ideas that might fade out of fashion down the road, because it's about the principles and the foundational principles that we all have agreed on in this country as citizens, and it's something that if they want to change it, then they have to go through the proper processes to change the Constitution, right? Which is very different.
Right.
Mm-hmm.
And they also, I mean, it's a unique blessing in the history of mankind to have part of your government that you can go to for justice against your government.
Right.
I mean, that's very, very rare. Mm-hmm. The judiciary exists to hear these claims that another part of the government, whether it's the legislature or the executive branch, at any level, state or federal or local, even, that you can go to, this part of the government for a remedy against government. I mean, it is one of the things that makes the Constitution, such an ingenious document. And that really, since the 14th Amendment and incorporating the Bill of Rights against mm-hmm. the states, that since then, states can provide more protection for your rights than the U.S. Constitution. They just can't provide less. So if they're doing something that is, beneath that floor that the Bill of Rights provided, then you have access to the judiciary for vindication. And it's that separation of powers that the founders, again, kind of knowing the fallen nature of man, that when people are in power, they protect that power. They used that and turned it on itself. And we're going to divide it amongst three branches, knowing that each branch is going to zealously guard its own power, and that will keep the other two from getting too big. And then, no one branch is ever going to get too powerful. Like, that's the whole point. So it's, and that's why it's so important that we keep, constantly reminding the general public of this via these cases. It's, if you lose that, there's nowhere left to go. I mean,
there's no other country.
Civilization, we're it. That are still, guarding these things as closely as we are. And so, sometimes these cases sort of serve as like the little Jiminy Cricket on the shoulder, like reminding us all, like, hey, I know you don't like that, what that guy's saying, but you should be, protecting his right to say it. It's sort of this. Yeah, go ahead.
I was just going to say, and this is what a lot of people don't realize, that in the United States, we do, if you read our Constitution and our Statement of Rights, it's all about the limitations that we're putting on the government itself, the government structure, saying what rights we have and what limitations the government has to infringe upon those rights. And if you read any other Statement of Rights for any country, even Western countries, all of Europe and Canada, they all write in limitations on the individual. They put limitations on the individuals themselves, not on what the government can do to those individuals. So this is something that, when they say, oh, everyone has the right to free speech, our Constitution doesn't say everyone has the right to free speech. It says that Congress shall make no law. And it really specifies that limitation on the government. And I think, just going back what you said, it's not just about the separation of powers. We talk about decentralization of power, because you talked about how easily corruptible centralized power is. We often think in the United States of the federal system, which is the federalist system, which is the separation of powers among the states, and that states have their own ability to govern themselves in their own ways from the federal government. But also, the three branches of government is part of that decentralization of the power, like you said, trying to put checks on each other in order to force the balancing act that will happen based on them guarding their own powers. So that's
and then
ultimately
the Ninth and the 10th Amendment that that build in that federalism. That look, if it's not stated here, then the federal government shouldn't be doing it. It should be the states. And that, even at the time that was adopted and ratified, life in New York was very, very different than life in Virginia, and they knew that, and that's okay. Right. Yeah. And if you like the way New York does things, then you live in New York. If you like the way Virginia does things, then you live in Virginia. Exactly. And it's the same thing. It establishes this baseline of there's a few things that are going to be the same everywhere, and everything else is up to the people in the states. Right. And they, and that combined with, like I said, like having this one branch of government that you can go to for help when one of the others is abusive of these rights,
right?
And giving that, especially the federal judiciary, sort of the life tenure and the immunity from the ballot box, because they were keenly aware, as I said before, of the potential of the tyranny of majority, that 50% plus one can vote if they want to try to take the rights away of the other 49%, and so they empowered the judicial branch to say, look, if the will of the people conflicts with these principles, it's the judiciary's job to say no.
Right.
But if the people want it bad enough, here's a process. You can amend the Constitution, right? And it's not easy, nor should it be, because we shouldn't be changing these fundamental things, willy-nilly. But it all goes back to this is the thing that separates us. It makes us unique in the history of the world, and that's why a case like Lord Smith's is so important. Just continually reaffirming that, regardless of what cultural winds have shifted from 1789 to today.
No, absolutely, and we talk about the importance of the Constitution, and oftentimes people kind of throw it around and say, yes, the Constitution, my constitutional rights, this violates my constitutional rights. These are my, this is my right, my power, whatever. But then they turn around from there and rely very heavily on the federal government to dictate many things in their lives. So there's a bit of a cognitive dissonance when it comes to understanding the proper role of the constitutional protections that we have put in place for ourselves, and understanding the proper role of essentially what the presidential administration. Because oftentimes when people refer to the federal government, they're referring to the behemoth that is the administration at this point. But people do rely so heavily on the administrative services that are provided that they forget that they have these rights, that they can actually use this Constitution, this Bill of Rights, to defend themselves, and that there's a legal system in place to defend yourself. So, what I hate to see is when I'm on college campuses, a lot of students don't even, regardless of whether they've actually read the Constitution is one question, but oftentimes they don't even see the opportunity to defend their rights. They don't realize there's one question of like, are my rights actually being violated? And the second question of, how do I defend them? And so, like you said, having this judicial system make these major decisions, I think catches everyone's attention and makes them realize, wait a second, we have a process here that actually can help in many of these situations, and that the Constitution actually supersedes all of these, Congress and the Supreme Court and the executive branch as well.
Yeah, that's exactly right. I say it all the time. You don't have to be a lawyer, you don't have to be a constitutional scholar, but you do need to know enough about your rights to know when they're being violated, right? And to know what to do about it. And you don't have to know all the legal strategy. That's why you can find folks like us, or Speech First. But you do need to know enough to understand what's going on, and understand that you don't have to put up with this, and that there is a way to combat it, and to do so in the system that was established for that very purpose.
Right. Exactly. Well, thank you so much, Lathan, for coming on to the show once again. Congratulations again on the big win for ADF. Looking forward to see what you guys take on next. Thank you, everyone, for joining us today. I'm Cherise Trump, and Lathan, that was well said.